Hello, everyone, and welcome to our webinar. I'm David Vandenberg, Chair of NAFA's Transactional Integrity Working Group. Our committee works to educate members on topics of illegality and fraud, which can occur at any stage of a transaction, and we provide resources on the NAFA website that can help mitigate those risks. Please feel free to reach out to info@nafa.aero to ask questions about our committee or suggest topics for future webinars. I'm pleased to present today's webinar on operational issues, what you need to know post-sale. I want to take a moment to thank TVPX, the sponsor of today's webinar. TVPX is a leader in the global marketplace, providing a range of services with the highest levels of customer service for more than 20 years. TVPX is a licensed U.S. customs broker specializing in the import and export of business and commercial aircraft through U.S. Customs and Border Protection. TVPX also provides registration, trust, and tax services related to business aviation. Now I'll turn it over to our moderator, Jeff Towers, Vice President and General Counsel at TVPX, to start the webinar. Thank you.
Thank you very much, David. First thing I'd like to say thank you to NAFA for supporting this initiative for due diligence webinars and providing the webinar capabilities to be able to present it. As most of you are probably aware, NAFA also allows us to posts the webinars, recorded copies of the webinars on NAFA's web page under the transactional integrity page. So you can see both this webinar and all prior webinars on NAFA's website. I'd like to introduce our speakers today. First, Scott McCreary from McAfee and Taft, who is somebody who has worked in the industry for a long time and is very well known as a speaker and, of course, very integral to the Oklahoma City attorney and escrow groups, very important to our industry, of course. John Copley is with Garofalo, Gerlich, and Heinbach in Washington, D.C. John is involved both in transactional matters involving aircraft, as well as being very knowledgeable on DOT and other regulatory issues relating to aircraft operations. The subject we're covering today, as you know, is operational issues, and we're going to be talking about some of the basics about what kind of companies are set up for aircraft operations, what the requirements are for those companies. A lot of people, as we know, start out their process of buying an aircraft with the assumption that they'd set up their companies much like they might set up a company for real estate purposes, only to realize later in the game that that might not work well from an FAA perspective because of the particular FAA requirements. So we're going to talk about that. We're going to talk a little bit about just from a lender or a lessor's perspective, how should we be looking at these situations? How are their clients going to be using the aircraft, and what are the implications if perhaps their lessors or borrowers happen to use the aircraft in a way that is not in compliance with the FAA's restrictions? What are the implications to the lender? Does it affect repossession rights? Does it affect any of your other remedies? Does it affect the value of the aircraft potentially in a long-term sense? Does it impact the availability of insurance? So these are things that we're going to touch on as we go along. And first, I'm going to turn it over to Scott McCreary.
Thanks, Jeff. So yeah, from as Jeff explained, I think what John and I want to do is focus on this more from a lender's perspective. So a lot of these issues are very complex, and we don't have time to dig into them too deeply. But just describing the issues and how an aircraft is operated, both before you close and after you close, and what the lenders should be doing as far as maintaining that and watching that is how we want to focus on the presentation today. I think the issue for the lenders primarily is that even though the lender may not be primarily obligated for some of the operational issues, if an aircraft is for some reason operated illegally or grounded, it creates complications and issues for the lender, either if they have to go repossess the aircraft in the future or just dealing with that scenario as they go forward. So with that, kick it back to John for.
Yeah. So I thought maybe before we jump into it, since we're going to cover different terms, I would just sort of touch on what it is that we're talking about. So when we're talking about Part 91, those are the general aviation rules that apply to the operation of aircraft. And that's generally what corporate aircraft fly under. We're also going to talk about the commercial rules, which are under Part 135 and 121. And that's usually what you see with air carriers. And for corporate size aircraft, you're looking at 135. So the initial distinction that we're going to talk about is the difference between general aviation rules and commercial aviation rules. And those depend upon the concept for the FAA is whether it's for compensation or hire. And compensation is a very broad concept. So even, compensation between related entities would force you into a commercial part of the federal aviation regulations unless there's a exception to it. And we're also going to talk about the difference between private non-common carriage and common carriage. So common carriage means that you're holding out to the public transportation for compensation. And then non-common carriage would be carriage that's not held out to the public, but it might be in essence for other entities as well. And that doesn't necessarily mean much for corporate aviation, but it does mean quite a bit when you're looking at the 135 air carriers that may be operating the aircraft asset that you're lending on. So in the first slide, obviously, that's what we're covering. So in terms of what you need to look for when the borrower is looking at their aircraft is you need to determine whether the aircraft, in fact, qualifies, that is the aircraft itself, whether it will qualify for the way that it's intended to be operated. And that is what you would do is you would look at its type certificate. And what the type certificate is that's the certificate that's issued to the manufacturer to which the aircraft must conform in order to be airworthy. So you would look at its type certificate. And that's how you can tell whether it's going to fit with the intended use of it and whether that's Part 91 and also whether it would fit if they want to use it for commercial purposes under 135 or 121. So that's the importance that you're going to have in terms of verifying the eligibility and compliance of the aircraft itself for its intended use by the borrower. So if you want to go to the next slide. So it's probably not that common, but there are times in which an aircraft can't be operated under Part 91. So for example, if you have an aircraft, and this occurs when you're looking at executive configured aircraft like a BBJ, a 737, or some of the Airbus or Embraer aircraft. But if you have an aircraft that is, its type certificate sets it up for more than 20 passengers or it's greater than 6,000 pounds payload, it actually cannot be operated under Part 91. It would have to be operated under what's called Part 125, which is for non-common carriage, or it would be operated under 121, and in some instances might be operated under 135. So one of the things to think about when your borrower is looking at the aircraft and you're looking at financing it is, does this aircraft actually fit the parameters that are needed for the intended operations, or is there a problem from the beginning? I mean, obviously, when you're looking at the aircraft, the first thing people should be looking at is whether it fits the intended mission, but you should also look at, does it fit the regulatory requirements for the intended use of the aircraft? So if you want to go on to the next slide. So as I started out, the watchwords for the FAA is whether an operation is for compensation or hire. And compensation is an extremely broad concept for the FAA. And if you look at the interpretations and the case law, it's purposely made broad by the FAA. It's not just receipt of money. It's not even just a profit motive. Any quid pro quo might be considered compensation. So when you're looking at the security and loan agreements, the question is, what is the terms that are in there? How are they defining it? Are they referencing the particular FARs, or are they referencing compensation or hire? And so exactly how is that set out? And then also exactly how do you want that asset that you're lending on to be used? So commercial operations, generally, you're going to require an air carrier or a commercial operator certificate. And in general, those are going to be Part 135 for corporate sized aircraft. For the larger aircraft, it may be the 121 certificates. And as we went over, if you're talking about some of the airliners that have been configured for executive use, it might be under 125. It used to be you could get deviations from 125, but that's not really true anymore. You have to hold the full 125. Now, what is possible and what you'll find is typical in corporate operations is there are exceptions to the requirement to hold an air carrier or a commercial operator certificate. And those are found in 91501 of the FARs. And what you'll see typically there is there's a provision in 91501B that addresses compensation that might flow from subsidiaries and parents, and from parents to subsidiaries. There's exceptions for that. There are also specific exceptions for what are called time-sharing agreements. Time-sharing agreements are typically used with executives. They are, in fact, a wet lease, and they permit a set amount of compensation, which is actually defined within the rules themselves. It comes out to roughly twice the cost of fuel with some incidentals. It's also permitted that you may have interchange agreements, you may have joint ownership agreements as well. So obviously, you may think, from the lending standpoint, well, you're obviously going to have to approve the time sharing, the interchange, or the joint ownership agreement, and you're going to end up with a consent that you're going to see, and you're going to review those. But it's also possible, for example, under 91501 B5 for compensation to flow back from the executive, particular executive. So you have to think about how it's being done, and is your borrower aware of what they can and they can't do. For 91501 to apply, you have to have an aircraft that has a maximum takeoff weight of 12,500 pounds. And there is a way for companies to actually fall within the provisions of 91501, even if the aircraft doesn't meet that standard. You can get an exemption. The typical way people do is the NBAA, for example, has a small aircraft exemption, and you can come under that exemption, but then they have to comply with that. So what you would be looking for from the borrower is Do they know what size aircraft they have? Have they thought about the exemption? Are they going to comply with the terms of that exemption? And again, so any reimbursement, even without the profit, would make it a commercial operation that you would have to hold an air carrier commercial operator certificate. But there are very particular exceptions to that rule that are contained within 91.
Yeah, to follow up on that a little bit, from a lender's perspective on a joint ownership agreement, that's normally, discussed up front, because in the typical joint ownership arrangement, each of the co-owners are registered owners of record with the FAA. And so lenders have focused on that, and they've decided that they're okay with that structure, but they also have to, keep in mind that if they're going to finance an aircraft that has co-registered owners, they probably want to have all of the co-owners as part of the financing, or at least be able to have them jointly and severally liable so they can repossess the entire aircraft. They don't necessarily want to be in a position where you're repossessing a 25% interest in an aircraft that you can't sell very easily to a third party. Time sharing agreements and interchange agreements, as John said, those are wet leases. Those agreements are not recordable with the FAA. So as a post-closing matter, if they're entered into, many of the loan documents will address whether or not their time sharing and interchanges are allowed in the future. But it's not quite as big of an issue because you're not transferring operational control of the aircraft to a third party. It's as John indicated, it's a wet lease.
Scott, in addition to the configuration of the aircraft that John was talking about and the financial arrangements for paying for the expenses and all, the FAA also could have some concerns about the nature of the businesses operated by those companies that are involved in the ownership and operation of the aircraft. Can you talk a little bit about that?
Well, sure. So there are different types of issues that could, apply there. One is the special purpose entity issue that John mentioned before. And so this seems to be one of the most common problems that we see when representing lenders, especially lenders where they're loaning money on aircraft that are either lower value aircraft or first-time aircraft owners, and their debtors don't understand the special purpose company issue. And the issue is that even though with most assets, if it's a risky asset in some other area, real estate or whatever, parties, the first thing they want to do is put the aircraft or the asset in a special purpose company to silo risk and for risk reasons. But from an FAA perspective, the FAA's issued lots of opinions, and they've indicated that you can't do that and operate an aircraft out of a special purpose company and operate at Part 91 because it's by definition providing charter. And so the lenders, on these scenarios where lenders are loaning money and the debtors don't really know what they're doing, this comes up quite often. And you really don't want to allow the debtor to do that, because not only are they potentially operating illegally, but if you're knowingly operating illegally, there could be negligence per se for that operation, and it could cause issues with insurance coverage and possibly the FAA grounding the aircraft for illegal charter operations.
So, Scott, can you elaborate just a little bit more on two things having to do with the special purpose entity? What is the problem with a special purpose entity operating the aircraft? What are they lacking, I guess is a good way to put it, that makes their operations arguably inconsistent with the Part 91 requirements?
Well, so in a special purpose company scenario, if I form Scott McCreary LLC to own my aircraft, Scott McCreary LLC has no purpose business other than owning and operating that aircraft. And so by definition, it's providing a charter service for me, even though it's flying me from point A to point B. I'm having to pay Scott McCreary LLC to do that. I mean, it has no funds or money coming in. And so by definition, its sole purpose is holding out to provide air transportation. And by definition, that has to be done under Part 135 or Part 121.
Okay, thanks.
And so one of the tools that debtors use and lenders should be aware of to help solve this, either the special purpose company issue or sharing the use of their aircraft with other related companies, are leases. And so there's nothing wrong with owning an aircraft in a special purpose company. It's operating the aircraft out of the special purpose company that's the issue. So there are basically two types of leases that the industry talks about all the time. One is a wet lease, and a wet lease is a scenario where the aircraft's leased with pilot and crew, but the lessor, in essence, remains in operational control. So the lessee they really don't operate the aircraft. Really, they're just buying hours, flight time on the aircraft. And under a wet lease scenario, like a timeshare, like an interchange, or like a improperly structured lease arrangement, you can't operate that under Part 91. But a dry lease is a different story. A dry lease is where the debtor leases the aircraft to the lessee, and they truly transfer operational control to the lessee. It's often they're leasing the aircraft without pilot and without crew, and the lessee is assuming operational control of the aircraft for those flights. So you can have a dry lease from a special purpose company. Let's say in my example from Scott McCreary LLC, I could dry lease the aircraft to myself individually, and then I could operate the aircraft legally under Part 91, because now I'm not a special purpose company. I'm now in operational control, and so I can conduct that flight legally. Determining whether a lease is a wet lease or a dry lease can get complicated, and we don't have a tremendous amount of time to go into that on this webinar, but it's a lot of the elements of when a lease is a wet lease or a dry lease are set out in an FAA advisory circular. It's a 91.37B, and they talk about issues such as who assigns the crew to the flight, who actually fuels the flight, who initiates the flight, lessor or lessee, who hires the pilots, who's hiring the pilots. Are they a third party contracted pilots, or are they actually hired by the lessor? Who maintains the aircraft, who insures the aircraft. So there are a lot of elements that the FAA would look at to determine whether or not a lease is a wet lease or a dry lease, and therefore would allow Part 91 operation.
Yeah, I mean, one of the things on the wet leases to keep in mind is that the FAA has a line of cases and interpretations, sometimes referred to as the sham 135. And what that is, you have separate entities. One entity is providing the pilot, and the other entity is providing the aircraft. So it looks like a dry lease, but the FAA looks at it, and the question they ask is, was this presented as a transportation service, or was this truly presented as a dry lease in which, it's only the aircraft and then you have to go out and get the pilots? I think a lot of times companies run afoul of this, where you've got a number of leases and then you're wanting to use the same pilots for each lease. So it's not necessarily wrong, but I think if you see that kind of structure, just to ask some questions about it and figure out exactly how they're doing it so that they have got it structured properly.
Right. And again, from the lender's perspective, from a big picture perspective, it's identifying the fact that your debtor is leasing the aircraft and getting, just just make sure it looks generally okay. I mean, you don't necessarily have to dig into all the details, but it needs to pass the smell test. It needs to pass the basic elements of a dry lease, or possibly you need to speak more with your debtor about it. Also, leasing, if you have an aircraft that is in excess of 12,500 pounds maximum certificated takeoff weight, it would be subject to truth in leasing requirements of Federal Aviation Regulation Section 91.23. And it's kind of a mechanical statute or section, the things that you have to comply with. But especially if in a finance scenario, if it's a finance lease where the lender or the bank is the lessor, you may actually be required to make sure these things have been complied with, and your lessee may or may not be the right entity to have made these notifications. But if your aircraft falls under the truth in leasing requirements of 9123, you have to notify the Flight Standards District Office at least 48 hours prior to the first flight on the aircraft under the lease. This comes up a lot where clients know that they're going to, let's say, close on Thursday, but they wait too late to give the notice to the FSDO that they plan to make a flight, Thursday at closing under the lease. So parties need to make sure that if they're leasing the aircraft, they're complying with this notice requirement. The lease has to have a truth in leasing clause in it. It's in all caps above the signature blocks of the lease, and it's a specific clause with specific language. It can be modified a bit, but it's a rather standard clause that's set out in this advisory circular. And you have to file that lease with the FAA Aircraft Registry within 24 hours of its execution. The filing with the FAA is not a perfection filing, so filing the lease for recordation is not the same thing as making a truth in leasing filing. And you have to carry a copy of the lease on board the aircraft if you're flying under that lease. So again, things that as a lender or a lessor, you need to at least make sure your debtor understands and that they know to comply with this, or make sure that they are complying with it. If you're leasing the aircraft, if you're using a lease to solve some of these special purpose company issues or the compensation issues, there's always the question of, what does the lender do as far as perfecting their rights in the lease or in the aircraft? And so it might be different if your credit analysis as a lender, if you're relying on rentals that are coming under this lease as part of the credit analysis, or covenants from the operator or the lessee are critical to the analysis, then you very well may want to perfect your collateral assignment of that lease. If it's a true third-party lease, you're probably more likely to want to perfect that. If it's a related company party lease, there might be reasons why you're not as worried about it. But if you look at this and you're really looking at the collateral assignment of the lease as part of the security package, then you need to perfect that. And how you perfect that is there are basically three ways. One is you have to record that lease with the FAA along with the assignment of the lease. So in that scenario, if you want to be perfected in the lease itself, you would need to record it with the FAA. Also, if the transaction falls under the Cape Town Treaty, you would also want to register that lease on the International Registry and assign it on the International Registry. And then in addition, as a fail-safe, to perfect under the UCC. So a lot of this depends on how important the rentals are, the collateral assignment of the lease are to the lender. But if they're important, then you need to make sure that the parties are following through with these steps for a lease that's at closing, or if you allow the debtor to lease the aircraft in the future, then you would want to do this in the future. Most lease deals, if we have now where lenders allow leases and they actually want to perfect them, or they record them at the FAA and register them on the International Registry, they're obtaining powers of attorney from the lessees, so that if they have to repossess the aircraft in the default scenario, They could actually execute a termination and clear the record of that lease. And they're allowing or requiring standstill and subordination types of documents from the lessee.
John, could you maybe go into a little bit more detail about Part 135 and Part 121 and the distinctions between the two?
Yeah. So one of the things, I think normally when you think about Part 135, what is thought and actually what is probably typical are the on-demand negotiated charters. That is, those are single entity, only one person chartering the aircraft, and there is negotiation as far as the origin, destination, and the time of the charter. And so the way that the aircraft is used under those kinds of charters, tends to be a little bit less harsh than it might be used under other types of charters. But once the 135 is permitted, and you have to look at, again, the specifics of the loan and the security agreement, exactly how it's worded and exactly what is permitted. 135 and the definition of on-demand operations includes not only that sort of what you think of as on-demand negotiated charters with a single entity, it could also include public charter operations under Part 380. And what Part 380 is it permits entities that are called indirect air carriers to charter the aircraft and then to sell it out by seats. The typical Part 380 that you would think of would be somebody like Apple Vacations, where they're chartering an aircraft and then they're selling it out. But that's also possible under Part 135. It's true that right now the FAA and some others have gotten upset about the use of Part 380 with air carriers under 135. And there's been some suggestions that those rules might be changed, and there has been a change as far as TSA. But up till now, the FAA, as far as I can tell, and I updated it yesterday, has not submitted that rulemaking. And so at the moment, you can end up with a Part 380 public charter under 135. And so your aircraft asset might be being used in that way. 135 also permits private carriage, which you would expect. And a lot of times I think, now what you may find is that your borrower is going under 135 simply because they can now. There's an advantage to the borrower to doing that because it means that the air carrier is the one with the responsibility for operational control. So from a regulatory liability standpoint, you have the air carrier in that position, and it's not the borrower that has to deal with that. And there's been changes with regards to the federal excise tax that I think has facilitated more of that, so that you're not stuck paying the federal excise tax just because you want the air carrier to operate the aircraft for you. So it may be that that's all your borrower is looking for. So you have to sort of figure out not just, well, it's Part 135, but exactly what are they going to do and what's their intent with the aircraft. And the other thing is Part 135 also does permit a type of commuter operation, that is published scheduled operations per seat on the aircraft. So, but those are actually 9 seats or less. So it's smaller aircraft. But again, it's a matter of knowing precisely what it is the borrower intends, why it is they want the Part 135, and then of course what it is that you're comfortable with and what does the security agreement say. And then obviously it also includes rotorcraft. And at this point, actually, as well, due to changes in the DOT regulations, you may have 135 per seat, or what would look like per seat charters that are being done under Part 295 of the DOT regulations. So even if you don't have the others, you may have that going on. And again, it's a matter of, is that how you're comfortable with the asset being used in that way or not? So if you're in the Part 121, for the most part, you're going to know it. Those are the large airliners, and they're going to be used in scheduled service or charter operations or cargo operations, and those are the larger aircraft. So I think you have to pay attention to that. But I think that if somebody is lending in that space, they're going to be well aware of what's going on and what the lessee intends with the aircraft. Um, the other thing to think about actually with the 135 and 121 is that the regulations under those parts are actually stricter, so that the aircraft equipment that has to be on there is probably going to be more redundant. You're going to have additional crew training. You're going to have additional maintenance. So in terms of taking care of the asset, there may be some advantages for having it under Part 135. And also, I think in some ways, in terms of surveilling and monitoring the use of the aircraft, may be easier if it's under Part 135. So that's something to think about as well. As far as the aircraft configuration for commercial use, just like when the borrower is looking at the aircraft and they're thinking about operating under Part 91, making sure that, in fact, it is an aircraft that can be operated under Part 91. If they're looking at an aircraft and they intend to operate it under 135, it's also a matter of looking at the aircraft as to whether it can be conformed to Part 135 standards. And that would be looking at the equipment that's on there. Does it have a flight data recorder? Does it have the redundancies that it needs to have? Does it meet the safety standards? You can sometimes run into issues with STCs that may have been installed on an aircraft that's been operated under Part 91 or as a private aircraft, where they've installed an STC is a supplemental type certificate, which permits you, in essence, to change the specifics of airworthiness under the type certificate. So you may have, some STCs that have been installed on the aircraft that work fine under Part 91, but they have a door, and so it impedes egress of the aircraft. And so the aircraft, in fact, can't be used under 135 unless that is changed. And so in the way in which you're valuing the aircraft and the way in which you're financing it might change depending on knowing exactly what the borrower is going to have to do. It used to be a problem in the past as well with private aircraft in terms of the materials that had been used in the cabin itself. And there was, they have to be fire blocked in order to meet the 135 and commercial standards, where you don't have to do that for private standards. I think, quite frankly, it's less of a problem now than it used to be. I think for the most part, private aircraft in that sense do meet the higher commercial standards. But again, you have to be aware of it and make sure that the borrower is aware of it. So the other thing to do is, obviously, if you're going to permit the borrower to operate the aircraft under Part 135, is to take a look at the 135 air carrier that's going to operate the aircraft. And you need to make sure that their air carrier certificate meets what those intended post-closing operations are. Again, for the most part, it'll be in common carriers, but is that what they have? And also, in addition to other things, you have to be aware that 135 certificates common different flavors. There are single pilot 135s, basic 135s, and then full 135s. So just the fact that they're placing it with someone who has a Part 135 certificate may not be enough, and it also, may not give the sort of comfort that you would normally think that comes with an air carrier certificate. So it's a matter of looking at it, verifying that in fact they do have a valid and effective air carrier certificate, and then what type of air carrier certificate do they have, since they're going to be operating and maintaining that aircraft. And so one of the things you would probably want to do is look at the operator's operation specifications, or people refer to them as the op specs. And then, one of the obvious things is, is this an aircraft type that they've operated before? Are there any limitations in there? You might also look at things like, does this air carrier, are they an Argus, or what other sort of third-party audit companies have approved this air carrier, to make a determination as to whether it's somebody that you want to be taking care of this asset. And then also, as we've talked about before, you want to distinguish between how they're going to operate it under 135. Is this going to end up as an aircraft that's used in single seat scheduled operations, in which case the wear and tear is probably going to be a lot more than if it's operated in the sort of traditional on-demand single entity negotiated charter operations, in which case, there are going to be probably fewer individuals, and the aircraft's probably going to be treated in a slightly better manner. So those are things to think about beyond just, okay, it's a 135 and they're going to operate it, but what kind of 135, and then how are they going to operate it?
John, a couple quick questions for people who might be getting involved with a lender, lessor, whatever, whoever they might be. Is there a quick way to at least take a look somewhere and say, yes, this company that I'm dealing with, who says they're going to charter the aircraft, in fact, are authorized by the FAA to operate aircraft for charter?
Yeah, so there is a very quick way. The FAA has changed it around to determine whether, in fact, they hold a Part 135 certificate. The FAA actually publishes a spreadsheet that shows who holds those air carrier certificates, as to whether it's an actual air carrier, and you can find that. It also provides the aircraft that are assigned to that particular air carrier certificate. I'm not making any representations as to the FAA's databases. I once went to the database to find information as far as repair stations and their certificates, and they had removed it. But hopefully the FAA will keep the database as far as air carriers up and running, but that will give you the basic information. And then for the op specs, you would actually have to request that from the air carrier in order to review it.
Thanks.
And this is something that's somewhat new, and at least it's becoming a little bit more popular now. And this is DOT Part 295, which governs what are called air charter brokers. Air charter brokers are technically indirect air carriers, the same as public charter operators. The difference being, if you're going to operate under Part 380, you have to jump through a lot of hoops. You have to have a bond. You have to file a prospectus with the DOT. You have to have escrow accounts that deal with the money. So there's a lot less of the Part 380 public charters out there than there are now with air charter brokers, because to be an air charter broker, all you really need is a phone, access to an aircraft, and comply with the rules in Part 295. So you might want to review the purchaser's broker arrangements with the 135 air carrier. I mean, the truth is, I think in the industry at this point, most 135s are going through air charter brokers. Those are the ones that have the business. There isn't necessarily an issue with them using the air charter brokers, but in terms of tracking funds and being able to get your hands on those funds, what you might find is that 135 air carrier, in fact, isn't the one that is in the front line, and they're not necessarily the ones that might hold the funds and hold the business. So if you had to go in and repossess, and then you had to take, in essence, over that lease to the 135 air carrier, it may not be all of the things that you're hoping for when you get there. And operational control, even with the 295, it remains with the Part 135 operator. The air charter broker is just an indirect air carrier, and they don't actually operate the aircraft. And then the Part 380 is the same thing. They're just indirect air carriers. There's a lot more hoops that they have to jump through with DOT to satisfy the requirements, but they're just an indirect air carrier as well. The other thing, once you know that it's going to be placed with a air taxi or an on-demand air carrier, and a lot of times it's sort of forgotten, but in addition to the FAA air carrier certificate, DOT also requires that you have a certificate of public convenience that's approved by DOT for air taxi operators and commuters. DOT has approved an exemption, which is contained in Part 298 of DOT's regulations. And so they're supposed to be registered with DOT, and also they're supposed to have their insurance filed with DOT. So I think if your borrower is placing the aircraft for 135 operations by an air taxi operator, you might want to check the Part 298 registration, or at least make sure that somewhere there's a requirement that's referencing the Part 298. I'd like to say there aren't any air carriers that forget about Part 298, but it does happen from time to time. So it's worth at least touching base on that. And then the other thing is, if they're going to be operating the aircraft, when you look at the management agreement or the lease that goes to the air carrier, you want to make sure that there's going to be a conformity inspection, and that before that aircraft is ever operated in commercial operations by the air carrier, that it's going to be placed upon their op specs and referenced as far as the DOT registration, just to make sure that they don't start flying charters before the aircraft is on their op specs, because that has happened more than once, and the FAA generally frowns upon it very much, and it's something they don't like, and you don't want to be involved in that, even if you're on the side as a financer.
Okay, great. So we have about 5 minutes left. Scott, could you maybe bring us up to speed on some of the registration requirements?
Certainly. So, everyone focuses on the fact that the aircraft needs to be properly registered at closing, and it needs to be registered so that it can be legally operated. But often people lose sight of the fact that registration has to continue and continue to be valid, or the aircraft's grounded. So it's not just a one-time thing where you look at the qualification of the debtor or the registration at closing, but it has to continue. And aircraft are registered at the FAA in the name of U.S. citizens, and there's a definition for that encompasses corporations and LLCs and other corporate entities, but it's a very specific test. It's an objective and a subjective test. It's not just that you formed a U.S. company. That company has to be owned by U.S. citizens, managed by U.S. citizens. Its voting interest has to be held by U.S. citizens, and so it's a very detailed and specific test. You can register aircraft in the name of permanent resident aliens, and you can register aircraft under what we call based and primarily used registration. And based and primarily used registration is limited to corporations. But if for some reason the aircraft have been registered under one of these scenarios and they no longer qualify for registration, there's no grace period. The registration is just instantly invalid, and the aircraft will be operated, or if it's operated, it would be operated illegally. And in theory, that could subject the debtor to, penalties from the FAA and fines and seizures possibly, and insurance issues, arguments that insurance might not be valid for a flight. So those are things that you need to monitor post-closing, and at least have built into the documents covenants that the debtor or borrower continues to comply with its registration requirements post-closing. We have a lot of scenarios now where aircraft are registered under where they have non-U.S. citizen involvement, so they don't typically meet the U.S. citizenship requirement on its face for registration, but there are some structures that you can put in place for the aircraft to meet citizenship requirements. One of them is using a voting trust to qualify a corporation that meets all of the other tests for citizenship. Another is, and probably the most commonly used structure, is a non-citizen owner trust structure, where aircraft is titled in the name of an owner trustee who's holding for the benefit of the non-citizen entity under a very specific type of trust with language in it that's required by the FAA. And based and primarily used registration often is available for parties where the aircraft is owned by a corporation, but the aircraft is based in the United States and it's primarily operated within the United States. And there's a test for that. In essence, it's 60% of its total flight hours in a 6-month measuring period are conducted within 2 points in the United States. But if you have a debtor that's qualified to register an aircraft under because it didn't meet the citizenship test and it's using one of these structures, you need to make sure that they continue to meet and qualify under these structures. So for instance, if you register on day one and the aircraft's under a based and primarily used registration, you need to monitor and make sure that it really is based and primarily used in the United States and it meets those rules as you go forward. Same thing with trust structures. You want to make sure the trust structures stay in place. If you needed a voting trust to qualify a corporation for registration, or if you have a non-citizen owner trust structure, that those structures are maintained and in place throughout the loan.
John, with a few minutes we have left, could you touch on the issues, DOT issues relating to aircraft that are being operated commercially in the U.S. by non-U.S. citizens?
Yeah, so one of the things to be cognizant of is that even though you may be able to register the aircraft at the FAA such that it's an unregistered aircraft, that doesn't necessarily clear things as far as its operation from a DOT standpoint. So from a DOT standpoint, if it's operated by a non-U.S. citizen, even if it's an unregistered aircraft, it's still considered a foreign civil aircraft, and it's subject to DOT Part 375. For the most part, it's set up now so that those rules primarily follow 91501 rules. So it looks a lot like if it were a U.S. citizen. Unfortunately, like a lot of things, DOT did not simply follow 91501, but they put their own language in there. So there are a few wrinkles here and there as to how you can operate an unregistered foreign civil aircraft. So if you've got a non-citizen, you might want to think about that. And you might also want to make sure that your borrower is cognizant of that and verify that they're complying with Part 375. And again, make sure that they're operating in a way that's permitted under the DOT regulations. You can actually get permits as well and authorization under Part 375 if the regulation itself doesn't meet what it is they intend to do with the aircraft. If not, they could be considered to be engaging in what DOT would consider cabotage, and there could be fines and penalties associated with that.
Can you talk very briefly about international operations and jurisdictional transactions?
Yeah, so if the aircraft is not just owned by a non-US citizen, but it might be relocated outside of the US, then you'd have to look at the export requirements under the customs regulations for an aircraft that's going to leave the US. Even though it would remain as an unregistered aircraft, it might still be required to be exported. And then you'd have to look at, on the other side, import regulations from the country to where it's going to be placed. And, the thing about the customs is, you have to worry about fines, penalties, and even seizures. So it's something to be cognizant of. And then you'd have to look at, the foreign regulations as to the operation of the aircraft when it's overseas, and then also evaluate from the lender's perspective your ability to get the aircraft back if it's outside of U.S. jurisdiction.
Yeah, and I might add to that, Jeff, we're seeing more and more examples of scenarios where buyers are purchasing aircraft and they're looking back at the history of where this aircraft's been based and operated, and making certain that the seller complied with any export and import requirements and now tariff issues. And so if a lender has to go repossess an aircraft that they have a financing on, it's certainly not out of the realm of possibility that any buyer is going to want the lender to make sure those things were done correctly before they buy the aircraft.
Great. One last thing before we wrap up, if Scott, if maybe you could mention some of the FAA's tools for helping people who are focused on privacy, that being an issue that's become more, I think, important since the murder of the insurance executive in New York late last year.
Absolutely. So we're seeing more and more borrowers, debtors that are very, very focused on privacy issues. And we're seeing, to start with, we're seeing them look more at what we call privacy trust structures, so that how the aircraft are registered with the FAA, they're registered in a way that limits the specific information about the borrower in the public record. They're fully complying with U.S. law as far as registering an aircraft, but they're doing it through these privacy trust structures. And in those scenarios, it actually might change how the lender looks at, how their documents are drafted, because you have these standalone trusts that are granting the security interest in the aircraft, not the borrower itself. They're not allowing these intra-company types of leases to be filed with the FAA, because those actually put back into the record information about who's truly operating it. And so there are a number of considerations for lenders if their debtors come to them and they want to use one of these privacy trust structures. And then they're also, operators are certainly focusing more on the LAD program and the PIA program through the FAA, as far as trying to limit how parties can track, their aircraft's flights as they go forward.
Well, I want to say thank you to the speakers and thank you to the audience for joining us today. Thank you again to NAFA, especially David Vandenberg and Tracy Cheek for their efforts putting this together. Again, our speakers are Scott McCreary from McAfee and Taft and John Copley with Garofalo, Gerlich, and Heinbach in DC. Thanks again. If you have any questions and want to get in touch with any of us, please feel free to. Thanks.
Thanks.